Now we're going to shift gears a little bit, and we're going to talk about civil disputes, particularly in international arbitration, where corruption issues arise. This has been an extremely active area in recent years, both in investor-state disputes and in international commercial arbitration. And yet the legal landscape for dealing with the issues of corruption in this arena is very undeveloped. There is only one convention in this area. The Council of Europe has a civil law convention against corruption, which has been in force along with the protocol for a number of years. And there's some provisions, as perhaps we'll hear about, in the United Nations Convention Against Corruption. But tribunals have generally been on their own in trying to figure out how to deal with allegations of corruption, or even what are called tacit cases of corruption when they are being called on to resolve a dispute. So we're going to hear in hybrid format from Pedro Martinez Fraga, who is a partner, as you heard, and the co-leader of the International Arbitration Team at Bryan, Leighton, Paisner in Miami and New York. He has represented many sovereigns. I won't try to count them for you, but I know he has encountered the issues we are going to be talking about. He is also a distinguished visiting practitioner of international law at NYU's School of Law and a full visiting professor at the University of Navarra School of Law. Like me, he's on the panel of Sociedad, and he's also active in the American Society of International Law, serving on its executive council. So Pedro, we're missing you here in Miami, but we're looking forward to hearing from you.
Well, thank you very much, Lucinda. Can you hear me okay? Good, excellent. Well, thank you so much, and thank you to the organizers for inviting me, asking me to be here. I would have loved to have been there with you, but I had a problem with my passport, and the only way I could have gone into the country and out of the country would have been through corrupt means, and of course that would not have been proper at all. Let me just say that, of course, corruption is ubiquitous, and international arbitration has been struggling with it, both international commercial arbitration, as Lucinda mentioned, and investor-state arbitration. First, let me just say a couple of words on the magnitude of corruption, and then we're going to get straight into some technical aspects that I think will be extremely helpful. Corruption, of course, even with dated figures going back to the World Forum of Global Competitiveness report, reflects that over $1 trillion in bribes a year are recorded, and developing countries pay approximately 25% more than what they would usually pay for services and goods in the international arena. Moreover, this translates into 10% more of the cost of doing business globally. If you were going to interpret this in terms of euros, it would cost the European Union approximately 120 billion euros a year, or 1% of its GDP, again, on an annual basis. The issue of corruption in international arbitration is a complex one, which actually brings into question the very anatomy of international arbitration. And as Lucinda pointed out, arbitrators are struggling for it for many reasons, but I'll try to narrow the particular reasons that I see, and the most effective ones that we need to focus on if we are going to create a rubric that sustainably and on an ongoing systematic basis would be able to address the issue of corruption. First and foremost, let me say a word on international commercial arbitration, the arbitration that, of course, arises from an arbitral agreement, an arbitral clause within a contract. In international arbitration, one of the foundational issues is what law will apply in determining the burden and the standard of proof. Now, with respect to the first, the burden, of proof, it is generally assumed and acknowledged that authori incumbit probatio, the alleging party of an affirmative claim defense or affirmative defense, would have the burden. But the standard of proof, which is actually more complex and more relevant in the context of dealing with allegations of corruption, becomes a metric, a standard that is critical, yet at the same time, this standard is fragmented, it is ill-defined, and it is almost subject to happenstance. Let me just try to be a little bit more particular. In international commercial arbitration, when it comes to the actual standard of proof, generally, and certainly this applies to corruption, it is unclear whether the standard of proof will be deemed to be a procedural issue that will be governed by the seat of the arbitration, the state where the arbitration is to be taking place, or if it's a substantive issue that will be governed by the applicable substantive law that the parties agreed upon. A third approach, and a minority of voices have talked about the standard of being governed by the law of the contract, not the law of the arbitration agreement, but the law of the contract where that applies. This issue is compounded and multiplied in terms of difficulty and lack of uniformity, because of course in some jurisdictions the standard of proof is a procedural issue. In other jurisdictions the standard of proof is a substantive issue. So there is no single rubric that clearly would apply. Again, there's an even greater layer of difficulty in that the common law jurisdictions typically have three standards of proof: preponderance of the evidence, or the likely probabilities test, clear and convincing evidence, and of course the criminal standard, which is beyond a reasonable doubt and to the exclusion of a reasonable doubt. On the civil law side, we have seen tribunals using the intimate conviction test that civil law jurisdictions usually have, convicción íntima, meaning whether the decision maker, an arbitral tribunal or a judge, feels an inner conviction that the proof is such that that standard of proof has been met. And here again, we are looking at standard of proof as we find it. Standard of proof is a relative framework, and burden of proof, deeply related but often confused even by very seasoned academics and practitioners, is more of a qualitative standard. The burden of proof always remains constant. So in the field of corruption and allegations having to do with corruption, the burden of proof cannot and is not a problem. But the standard of proof is a problem because, as we just saw, it is completely relative, and there's no single governing scheme in international commercial arbitration. In investor-state arbitration, we really do not fare any better. In investor-state arbitration, of course, what applies when you have corruption, generally speaking, is an analysis that first must start with the treaty. Most bilateral investment treaties contain a language either in the definition of investor or investment, but usually, and also in the promotional part of the treaty, that says that an investment must take place in accordance with national law. So that means that the investment has to be consonant with national law. It cannot violate national law. And of course, when you have a government procurement agreement that was secured through corruption, through bribery, or if you have an infrastructure contract that was secured through bribery, it is in violation of that national law. And therefore, typically, the way tribunals have reacted is by saying the underlying contract will be null and void. In these scenarios, in investor-state arbitration, and when we're dealing with the public international law of investment protection and the collateral customary international law and principles of international law that we find in Article 38 of the ICJ statute, we have to take into account that there is no definition of corruption that would be applicable. And there is absolutely no framework that applies to corruption in particular. So this creates a massive void that is left unclear. The way tribunals have addressed it has been really in three ways. First, focusing on the domestic law and therefore holding that it's a violation of domestic law, so the underlying contract will be null and void. But again, this leaves an issue. Assume this: the claimant brings a claim for breach of a treatment protection standard. Of course, the host state raises the corruption defense, calling for null and void. There's a finding that the underlying contract was secured through bribery or some form of corruption. As Lucinda pointed out, corruption, there's no one definition. There are many forms of corruption, and then it's held null and void. So there's no action. The claimant cannot recover. Now, what does this leave us with? It leaves us with a situation where the host state got out of its obligation if in fact it treated that investment in a way that was wrongful in its exercise of regulatory sovereignty, legislative sovereignty, executive sovereignty, or judicial sovereignty. So the claimant does not prosecute the claim, and the state, in some sense, comes off free and clear if it in fact exercised excessive sovereignty that ran against its equally important obligation to respect foreign direct investment. Here, of course, tribunals have wrestled with situations where there is an agent of the state, and the state cannot be held accountable for that agent's, of course, breach of his or her or its, if it's a department instrumentality or just an agency or representative, of its obligations to the state. On the other hand, agents have been held, agents of states and instrumentalities of states, their wrongful, intentional, whether tortious or criminal actions, have been held to be imputable to the state. So there is a clear issue here on whether the state, in effect, is being rewarded or held to be immune from any impunity, any wrongful action arising from its treatment of these issues. Finally, I wanted just to say a couple of things on the analyses. When we look at the analyses that have taken place in the context of both international commercial arbitration and investor-state arbitration, rarely do we see that the standard of proof has been clearly articulated and uniformly articulated. This is in large measure because there is no necessarily developed construct for precedent for res judicata, and the ad hoc formation and transformation of international arbitration systematically, its architecture militates against having one standard. It is here that we have a lot of work to do. All international commercial arbitration rules, most of them, if not all of them, do not have any particularity on being able to articulate a standard of proof. There is none, so we can improve there. National arbitration laws have nothing on the standard of proof. We can also improve there and have language amendments, academic work that supports standard of proof, a uniform standard of proof in international commercial arbitration and investor-state arbitration that, of course, will help parse through this problem, create uniformity, and help both claimants and respondents in something that would be equitable. Lastly, in closing, there has been a great deal of reaction to the way arbitrators have dealt with claims having to do with corruption. Many of them have held that the standard should be a very high standard because it's a very serious allegation. but this usually creates inequities with respect to the damaged parties. So the approach has to be one that balances the difficulty and the seriousness of the claim with a reasonable means of getting relief. And with that, I want to thank you for your patience and for your attention.
Thank you very much, Pedro, and we could hear you perfectly well. I will just say, for those of you who are interested in the commercial arbitration side and picking up on Pedro's focus on issues of burden and standard of proof, the International Chamber of Commerce has a task force on dealing with allegations of corruption in arbitration. I'm actually active in one part of it that's trying to grapple with the issue of red flags of corruption and how tribunals should deal with red flags, which are argued to be important circumstantial evidence, some people argue anyway, of corruption. But there's a lot of debate about how to deal with them in the context of corruption allegations. So I think we are completely in agreement, Pedro, that this issue is really embryonic and a bit of a mess. On the public international law side, you have all the attribution issues that you've highlighted. Some very thoughtful commentators have pointed to what they call the attribution asymmetry, where the acts of a company are all, a company's employees or agents are always attributed to the company, even if they're seeking personal benefits, while there are cases that have declined to attribute the acts of even heads of state involving bribery and corruption to those individuals. So there are many issues both in the commercial and the investor state space. And we can come back to some of these in the discussion, I hope, if they are of interest.